On the evening of April 9, 2022, a heavy burlap sack hits the dirt at a roadside junction in Odisha. Inside, investigators discovered 22 kilograms of cannabis, the flowering and fruiting tops of the plant, later verified by a chemical examiner. The trial court issued a severe sentence, 10 years of rigorous imprisonment and a fine of 100,000 rupees. 1 year later, the High Court of Orissa set aside the conviction and ordered the appellant to be set at liberty immediately. The appellate judges did not dispute the recovery of the drugs, nor did they claim the appellant was factually innocent of the crime. The acquittal turned entirely on a failure in the procedural chain of custody. In high-stakes narcotics law, the physical recovery of contraband carries zero legal weight without a mathematically perfect paper trail. Narcotics investigations in India are governed by the strictures of the NDPS Act of 1985. This specific case unraveled because of the requirements found in Section 55. Section 55 requires law enforcement to prove an unassailable, documented chain of custody from the moment of seizure at the crime scene to the moment of production in the courtroom. The prosecution must prove that the path from the seizure site to the lab was traveled trouble-free, thereby removing any possibility of evidence tampering. The responsibility for building this chain fell to the investigating officer, an excise inspector designated as Prosecution Witness 4, or PW4. We can pinpoint exactly where PW4's evidence chain collapsed by looking at the 24-hour window following the arrest. Administrative missteps, however small they seem, possess the power to unravel the largest narcotics convictions. The timeline begins at 6 p.m. on April 9th at Pakudibanda Junction. PW4 detains the suspect and seizes the contraband. Initially, the inspector follows protocol. He weighs the contents, replaces them in the bag, and applies his personal brass seal to secure the evidence. Once sealed, the officer must execute a zima, handing the brass seal over to a trusted third party for safekeeping, so the officer cannot later reopen the bag. PW4 handed his brass seal to PW2, an assistant sub-inspector on the very same raiding team. Keeping the evidentiary seal within the same prosecuting unit provides zero forensic insulation. To properly rule out tampering, the seal must be given to a verified, independent civilian witness who has no stake in the investigation. The High Court held that giving a seal to a direct subordinate is legally equivalent to the inspector keeping the seal in his own pocket. Entrusting the seal to a fellow team member fractures the first link in the custody chain, as it fails to eliminate the possibility of internal interference. Later that evening, the raiding party returned to the excise office with the suspect and the sealed bag. The bag was placed in the Malkhana, the secure evidence storage room inside the office. PW4 locked the seized bag inside the Malkhana to store it overnight before presenting it to the court. At this point, PW4 was the officer in charge of the Malkhana. He retained the only key to the room where the drugs were held. Proper procedure required him to hand the key and the formal charge of the room over to a different official to create a verified transfer of custody. Furthermore, during the trial, the prosecution failed to produce the Malkhana register to prove the evidence was ever actually logged into the facility. Without the logbook, the court views the room as a legal black box, leaving the door open for any number of undocumented interventions. On April 10th, PW4 produced the accused and the 22-kilogram bag before the special judge. The magistrate must legally open the bag and draw official 50-gram samples for chemical examination. Before opening the bag, the magistrate must physically compare the wax seal on the evidence against the original brass seal held by the zima holder. The trial record reveals a final fatal gap: the total absence of any record that a seal comparison actually took place. The assistant sub-inspector was in the courtroom with the seal, but the record does not show he ever offered it to the judge for verification. If the magistrate's order sheet does not explicitly state that the seals matched, an appellate court cannot assume the verification occurred. Without the magistrate's written confirmation of the seal's integrity, the entire proceeding chain of custody loses its legal standing. The internal seal, the missing Malkhana register, and the unverified magistrate order. These three failure points collectively strip the physical evidence of its legal standing. Individually, these details might seem like clerical oversights, but collectively, they create a canyon of doubt regarding the integrity of the seizure. The High Court was explicit, stating, "Such are not empty formalities or rituals, but necessities to eliminate the chance of tampering." The prosecution bears an uncompromising burden to prove the path from seizure to lab was traveled entirely trouble-free. Because PW4 maintained control over the evidence room and gave the seal to a subordinate, the chance of tampering remained legally present. Appellate courts never presume safe custody in NDPS cases. The burden remains on the prosecution to affirmatively document every link in the chain. Under Section 55, a single shadow of doubt regarding evidence integrity mandates an acquittal, regardless of the quantity of drugs seized. A successful narcotics prosecution requires flawless administrative rigor just as much as it requires solid investigative work.